Some people have construed this settlement agreement as rare breed looking out for rare breed, where you guys had Cargill, you've got Chevron deference no longer being an issue. You guys had all the momentum. You could have pushed it through. You could have gotten something more binding, not just a district court decision out of Texas, but something out of the Fifth Circuit, maybe even something out of the Supreme Court if you would have pressed ahead with this. But instead, you entered into an unenforceable agreement with the government, or the next administration could just tear up to save your own asses. How do you respond to that? Hey everyone, James Reeves. Thanks for tuning in. Today we're talking about the FRT, or the Forced Reset Trigger. Many of you have heard about the settlement between Rare Breed, the manufacturer of the Forced Reset Trigger, and the government, the ATF, Department of Justice. I've got a couple very special guests here on the program today to talk about it. First, I've got Lawrence DeMonico. You guys remember Lawrence. Lawrence, what do I call you? President, CEO?
President.
Top dog over at Rare Breed Triggers and Rare Breed Firearms.
That's right.
And then I've got Josiah Contarino.
That's right.
Lawyer for Rare Breed Triggers, Rare Breed Firearms. I wanted to ask you guys some questions because there's been some controversy relative to the settlement with the government. And I want to get to that as quickly as possible. But there may be some people tuning in who have no idea what a forced reset trigger is. There may be some people who maybe aren't pro-gun who are thinking, they're watching this thinking, man, this guy makes a machine gun part, a legal machine gun part. So let's go ahead and get it out of the way. Lawrence, what is the forced reset trigger?
The forced reset trigger, we brought the forced reset trigger to market in 2020. What the forced reset trigger does is it uses the action of the rifle to force a reset on the trigger to put it back in the ready state so that the shooter can pull the trigger or function the trigger much faster than you can in a standard semi-automatic trigger.
As simply as you can, how is this not, and again, this is kind of the crux of the litigation, how is this not a machine gun?
Well, the shooter must pull the trigger for every round fired. The trigger is locked between every round fired. The trigger resets between every round fired, and it only fires one round per function of the trigger. So therefore, it meets the statutory definition of not being a machine gun, and that is the technical distinction. So we started manufacturing in late 2020. I believe it was December of 2020. We probably put about 100,000 into the market. Now, about 6 months after going live, the ATF sent us a cease and desist letter. The cease and desist letter said, you're making machine guns, you need to stop. Now, in what world would they send a company that's actually making machine guns a cease and desist letter? They'd show up, kick in your door, and start making arrests. But not in our case. They sent us a letter and said, stop. Well, we were like firmly secure in our position and our understanding of the law. We knew that what we were manufacturing did not meet the legal definition of machine gun, so we politely informed the ATF that we would not comply with their unlawful demand.
Sure. And you and I actually had a conversation in Texas on this channel several years ago, right about when this happened. So it's interesting to see it come full circle. So how did you respond to the ATF's cease and desist? You already told them to pound sand, but it was more complicated than that. Who fired the first shot?
Okay, so we fired the first shot. We filed an action in the Middle District of Florida seeking a declaratory judgment. The ATF, in hindsight, and even at the time, I believe that they knew that they couldn't win on the merits. So they got creative and they had the case dismissed procedurally in the Middle District of Florida. We then, this is about the time we were moving our offices from Florida to North Dakota anyway. And we filed another action for a declaratory judgment in North Dakota. The DOJ once again got creative and had the case dismissed. I could go into the technicalities. It's not really all that important, but they were creative and got it dismissed. Now at that time, we started trying to look for a better way to pull this off, and we were just getting ready to file another action when the DOJ sued me. So they sued the owner of Rare Breed Triggers, Kevin Maxwell, also an attorney. They sued me personally, and then they sued rare breed triggers and rare breed firearms in New York. So they sued me for mail fraud and wire fraud, essentially saying that every package we had shipped was mail fraud and every payment we had taken was wire fraud. Once again, they didn't want to bother with the merits of the case.
Really, it goes to show that sometimes the government and any entity with more power than another makes the process the punishment. And that was definitely the case here, and we saw it in the Biden administration as well. So there were multiple steps, all those procedural aspects, not addressing the merits in the lawsuits before. But then in Brooklyn, petty things, discovery on a hyper truncated schedule, depositions where, do you remember this?
Oh yeah.
They weren't going to let Lawrence eat at lunch. I mean, just the pettiest things to get an edge because
I'm taking notes here. I like these strategies.
Because the merits they knew were going to fail them. They couldn't satisfy that part.
Like during the litigation in New York, we had to get really creative, and that's when we approached the National Association for Gun Rights. And when we approached them, it was tough. Like I shook all the trees. I asked for help from everyone, and I don't want to throw anyone under the bus, but pretty much every organization I asked. Every organization wouldn't answer the call. NAGR did. Now, what we decided to do is kind of team up with them to bring another action in the Northern District of Texas seeking a declaratory judgment. That is the specific case that took off.
We weren't going to get a fair shake in Brooklyn, New York. We had a Biden appointee judge, and seemed to play nice with us on procedural matters, but then when she was interpreting a firearm statute, she took every liberty she could. She completely twisted the burdens between the parties. Wherever she needed to find an inference for the government, she did. And that's the opposite of what she should have done. So we file in Northern District of Texas. It's an APA case, so the Administrative Procedures Act. And most of the information that we used successfully in Texas was from depositions and testimony that came out of New York. And Judge Okconor in Northern District of Texas read the statute just like any fifth grader could, looked at the testimony of the expert of the ATF, who said that the function of the trigger was occurring when it was releasing the hammer, and found in the favor of NAGR and its members.
You prevail what, after a bench trial or motion practice?
So there was the TRO initially, the temporary restraining order, then the preliminary injunction hearing. So that's kind of like a trial. Some of our experts and experts from the ATF were down there. Some of the lawyers from Brooklyn came down because this is, a whole process. They're working as a team with unlimited resources, the federal government is. And after that, cross motions for summary judgment.
Right.
And Judge Okconor denied theirs, granted ours. And that is the only final judgment that exists today, which is important for people to know, because when they want to know if there is precedent, well, there is, and it comes from Judge Okconor. In fact, a criminal judge also in Texas dismissed the government's case, citing Judge Okconor, and of course Cargill, which Judge Okconor relied on. So there were some concerns with settling before getting some precedent, but those concerns can be allayed because the only final judgment that exists today is from Judge Okconor, and it's that force reset triggers are legal.
Sure. Federal court case, but still at the district court level. Did it make it up to the Court of Appeals? Was there an appeal by the government?
So there's an appeal by the government to the Fifth Circuit. I think at the point of the settlement, there's like three cases really to hone in on. There's the Eastern District of New York, where a preliminary injunction, the first ruling in this case, was adverse to FRTs. So the Brooklyn court said that very likely they're illegal because it was a preliminary injunction, not a final ruling. We appealed that. And then there's Judge O'Connor's case, and his order, final judgment, and the government appeals that, of course. So we have the Second Circuit and the Fifth Circuit. And then there was another case also in Utah, which is the 10th Circuit. So when you look at what happened in settling at this juncture, it's important for all parties to look at what's the worst that could happen and what's probably going to happen. So the worst that can happen is Judge O'Connor's ruling is just trimmed down completely. And the ATF was making arguments to that effect. Associational standing, they wanted to knock that off, which, they had some reasonable claims and arguments to make. We thought we would prevail, but that's one thing. Another is, people might not know this, that the members that were granted relief by Judge O'Connor, the ATF took the position that not all members, just members that were members before the litigation occurred. Those two things, and then another, Judge O'Connor said they couldn't bring criminal charges against Lawrence and Maxwell. Those are very important things to these two gentlemen. And the government said that they were arguing on appeal that couldn't happen. And the Fifth Circuit, there was oral argument, probed into that a bit. So again, we felt confident, but there's always that risk.
Sure. So Josiah, and I can see where this is going. You guys are anticipating that we're about to get into the questions over how prudent it was to enter into this settlement agreement with the government. And I see that's we're on that trajectory right now. But if I can restate essentially what you told me, I'm seeing this as, look, we were confident that we would prevail in the Fifth Circuit, possibly even if it goes up to the Supreme Court. However, the risks were too great, even though we were confident, for us to pass up a settlement such as this one. Is that a fair statement?
I'd say that's mostly correct, but it leaves out an important part of the general landscape. And I think two things really highlight that. One, there's almost no chance the Supreme Court's going to take this. They take 1% of cases that you try to get there, and they almost never do it on the backside of just deciding basically the same issue, which they did in Cargill, right?
Yeah.
So there's a risk there. They're not going to take it. Not even a risk. It's probable they're not going to take it. But then also, New York was not going our way. The Second Circuit is going to do everything they can to make FRTs illegal in the Second Circuit.
But
Sure.
there was no chance of bailing in the Second Circuit.
Right. So you guys have cases pending in Texas and in New York simultaneously. So you're trying to beat the buzzer with an essentially a more favorable jurisdiction. Let's call it what it is.
That's right.
In Texas. So you also had this time consideration that maybe a lot of people might not be considering. Is that a fair statement?
Oh,
Absolutely.
Okay, so that also made this more appealing to say, hey, let's get it done with right now before something possibly bad comes down from this case that we've got pending in New York. How did the settlement agreement begin?
Fairly interesting. As soon as the new administration took over, a couple executive orders right out of the gate. One, Trump he wanted people to identify issues where Second Amendment.
Biden's executive orders, and to identify them, and we're going to address
where they
them.
had kind of infringed on people's Second Amendment rights. Yeah. Well, also, they were looking for people to identify issues where weaponization of the government had occurred. So we kind of decided to go up both of those avenues.
Yeah, our firm wrote a letter just standard to DOJ, I think it was to Pam Bondi's office. There was a task force, as I understand it, and that's, I think a lot of people did, wrote, check this case out, please. We feel like if it's Second Amendment or Second Amendment adjacent, which this kind of was, since it was the statutory interpretation, Biden overstepped here. And there's no more proof in the pudding than Judge O'Connor's last paragraph of his summary judgment final order, where he said this case is about firearms, but it's even bigger than that. It's about a tyrannical government. And he said the government would do well to think back of the revolution, where we wanted to get out of this essentially monarchy, right? And that's what this case was also about, is pushing back on a tyrannical executive and unelected bureaucrats and prevailing, which is hard to do.
Josiah, you send a letter to Pam Bondi saying, look, this is something I need to bring to your attention in view of these initiatives from the Trump administration vis-a-vis the Second Amendment. Turns them on to Lawrence's case. Someone proposes the idea of maybe a settlement. Did that come from the DOJ or did that come from you guys?
Yeah, I think both parties knew there was an interest in resolving something where there's uncertainty. That's what a settlement does. It provides certainty. I think long game, I think NAGR, rare breed guys, they win. But that could be 4 or 5 years. Resources are obviously a concern. Guys spent millions just in the New York case alone.
The way you said that, I think is a common complaint that a lot of the critics of this settlement agreement have. When James J. Reeves, civil litigator, makes a settlement, I know it's binding. I know that there's going to be a judgment, a motion to dismiss with prejudice, and I know that this other party is never going to renege on this settlement. Otherwise, I'm going to be able to enforce it. I think the distinction here, and where a lot of people are critical, is the fact that the government can't contract away its enforcement powers here. What a lot of people are concerned with, myself included, is the next administration could just tear this up and say, hey guys, the federal government can't just settle and say we're not going to enforce the law. So how would you respond to that?
Yeah, absolutely. I mean, what would we do as a practical matter is we'd go back to the Northern District of Texas, if that were to occur, and file a motion to enforce the settlement.
2 issues that I potentially see with that. Number one, only you guys can enforce this settlement agreement. So if someone else gets in trouble for it down the road because there's an administration that decides to change their position or tear up the settlement agreement, you guys are the only ones who can enforce this settlement agreement. I mean, that's accurate, is it not?
It's actually not. So the provision in the settlement agreement says the rights for enforcement as a plaintiff in a civil matter are only the parties, the named parties. That it says nothing about rights of a defendant who is being prosecuted for possession or transfer of machine guns. So we see no reason why a defendant can not only waive the settlement agreement around, but say, look, I am given this right as an individual, that the government can't come after us.
Now, in addition, you have to look beyond the settlement agreement. Judge Okconor vacated the ATF's opinion that FRTs are machine guns. Vacatur is universal, and that should apply to anyone in the country regardless.
If the next administration comes in and they decide to tear this up and there's a criminal prosecution, that criminal defendant is going to be able to enforce this settlement agreement, or they're just relying on the decision from the Northern District of Texas, or both?
I don't think enforcing it would be the right word, but they would use it, and they would enter it into court in a motion to dismiss filing and say this is barred. I mean, this criminal proceeding can't happen because of this settlement agreement, and then they can go to Judge O'Connor's universal vacatur and say, also, this was already vacated. The ATF's attempt to prosecute or deem illegal FRTs is vacated.
The second issue I see is, let's say there's another administration comes in, they tear this up, they say we're not going to follow this. What concerns me is that maybe a court would say, hey, look, the government's actually right vis-a-vis the enforcement of the settlement agreement in that they can't contract away their enforcement powers. So all you get is money damages. And I guess the only people who would get money damages in that case would be rare breed.
Yeah, I think we would, again, file the motion to enforce the settlement agreement. And we think that's going to hold up and take it from there. But in terms of money damages, we're not really looking for money damages. We're looking for what the government agreed to. And that is that this is not illegal, but not only that, we rest on Judge O'Connor's, the only final judgment that stands nationwide, even though it is a district court, that says they're legal and what the ATF did was illegal.
And if we were to find ourselves in that position, there's one thing that's certain. We're no longer pinned down in the Second Circuit. And that case was dismissed with prejudice. They cannot bring it back. So we're no longer having to deal with that while we litigate the legality of an FRT.
Are you saying then that if you've got a blue administration or an anti-gun administration for that matter that comes in subsequent to the present administration, they say that they're not going to follow this settlement agreement, you move to enforce it in the Northern District of Texas, and do you think that the court is going to say, yes, U.S. government, you agreed that you weren't going to prosecute people for possession of these. You agreed that these were not machine guns. That's how that would shake out?
It's not about contracting away a legal right. The argument would be contracting away an illegal right.
And I want to make sure that we're clear here. I'm aware, as I believe, I would hope you are as well, that the government cannot contract away its enforcement powers. So that to me is kind of where I see the hang up. What you're saying is, look, no problem. We think that we would be able to get past this by enforcing the settlement agreement.
That's right.
Now that we've kind of got that behind us, I wanted to look at a couple of provisions that I think pique some interest for myself and others. Why was the government hung up on not making a force reset trigger for handguns?
Okay, well, I'm glad you asked that question. First, one of the things that people have been really confused about in the socials, and I've been getting beat up on, is pistols. And the DOJ really screwed the pooch when they put out their press release, because they also used the word pistol. And I don't think that was intentional. I'd like to give them a little bit of grace on that. But the word pistol is not used in the settlement agreement even one time.
It's handgun.
It is handgun. And specifically, when we sat down to negotiate this, and there were multiple trips to D.C., sitting across conference room tables with people to, work out these issues. They wanted pistols. They wanted AR pistols. They wanted MP5s. They wanted CZ Scorpions. And I drew a hard line in the sand. There's numerous problems there. If you can put an FRT in an AR rifle, well, guess what? It goes in an AR pistol as well. So that creates a problem. But we already have designed, developed, and patented models for, say, the MP5. And I'm not willing to give that up. Now, I will tell you, we had no intention and still have no intention to ever put them in a handgun. I know I'll get beat up for this. I'm going to say it anyway because I think I need to own it. I think they're ridiculous. In a typical handgun, I think they're dangerous. We felt that it was irresponsible as a company to put them in handguns. So when they asked for pistols, and I drew a hard line and said, no, but I'll give you handguns. And they were quick to jump on that. But also, I was quick to give it to them. I don't feel like we need that. Now, we made it a point in the settlement agreement to define handgun. And the way that we've defined it in the settlement agreement is if you can load the magazine through the trigger hand magwell, then it's a handgun. Now that does take a few things off the table that we'd prefer it not, say the MP7. I felt like it was very, very tough to try to draw a line exactly where we wanted it. So that's where we ended up putting it, and I'm happy with that, and I'll stand by that.
And again, I'm glad you said that. So don't think that I'm saying, well, you didn't answer my question. Really, my question was, why was the government, especially a pro-Second Amendment administration, why were they so hung up on this pistol thing?
I'll tell you what, it's very tough to know why they asked for some of the things they asked. But to be honest, when I was sitting there at that table and I had no issue giving it to them, I wasn't going to question them about why they wanted what they wanted. I didn't feel the need to poke back on. Obviously, I drew a line when it came to, say, AR pistols and CZ Scorpions and the like. But I didn't feel the need to question them why they didn't want them in handguns. And I don't think we need to argue whether or not they're legal. Do I think they're legal? Yep. Do I think that they qualify as a machine gun? Nope. So long as they meet the definition that was put out by Judge Okconor, no. I don't think they are machine guns. But were we going to make them? No. And I didn't care that they didn't want us to make them.
Another interesting provision that I saw in the settlement agreement, it's essentially like the federal government or the ATF is deputizing you to do its work through patent enforcement. there's this provision that says that you guys agree to enforce your patent against anyone else. And again, it's unusual because I would assume you would do that anyways. Right. We're giving you guys a monopoly on this. And you're now the ATF where you're going to go and sue anyone who does anything similar to what you do. How do you respond to that?
This one's good. This one's very laughable to me. I really thank you for the question. We have a very strong history of enforcing our patent rights. Like, we've been doing it since day one. So it was something we were going to do anyway. And this kind of comes back to the handgun issue. They wanted handguns off the table. I wasn't going to question it. We weren't going to do them anyway. So when they asked us to enforce our patent rights, it was a no-brainer for me. Now, I didn't ask them what their motives were. I can assume that it had to do with like our responsible marketing, because they also point out in the settlement agreement that we need to market it, responsibly. But if we're going to be honest, I don't know why they asked for it, but I was quick to give it to them. Now, the idea that this settlement agreement gives us some kind of like government sanctioned monopoly, we already have a government sanctioned monopoly. It's called a patent. And those patents were issued by the USPTO. So we've already got a monopoly. The entire idea of a patent is exclusivity. Through this patent, I get to exclude others from the market. I mean, that kind of is what a monopoly is. The Second Amendment is a part of the Constitution. Well, Article 1, Section 8 of the Constitution provides for patent rights. So when I hear some people celebrating the fact that we stood up for, 2A rights, but then shitting on me for enforcing our patent rights, I'm kind of like, you don't get to do that. Either you support the Constitution or you don't.
You are saying you were going to enforce your patent rights anyways.
Absolutely.
So to you, it's a non-issue, and you just want to get this settlement done with, and the government insisted on it, and you didn't ask why.
So it wasn't so much that I wanted to get it done quickly, but as I said, we've got a strong history of enforcing our patent rights. If they want me to continue doing that, it's a no-brainer. It wasn't worth me even asking about. It was just check, Roger, let's move on to the next issue.
Do you understand the suspicion? And I'm also gearing that towards Josiah as an attorney, because I see this and I'm like, that's weird. Why would they have a provision in here where I'm going to promise to enforce my patent rights? I mean, do you understand why people might be suspicious of why this is included?
I think it's reasonable, but once again, I didn't bother asking.
I don't blame people for reading just this document, not maybe understanding a patent has existed since, I think, 2019. But it's certainly not, this document, this settlement agreement did not deputize Rare Breed Trigger to do something. They were always going to enforce their patent. They took big risks in this case. There's a famous adage, big risk, big reward.
Right.
And that's I think that sums up the Rare Breed story.
But it is unusual to have this provision in a settlement agreement. Sure. Would you agree with that?
Yeah, I don't think that's it.
I also think it's fair to say a settlement agreement like this is already pretty unusual.
Fair enough. There was also some language in there. I kind of glossed over it. I'm like, that's kind of weird. Referring to other lawsuits, I think some in Florida that may have been related. What's that all about?
Okay, that's a good question. I've seen quite a bit of, questions about that on the socials and how odd that is. Well, when we sat down to negotiate this settlement, there were some unique instances with confidential informants that had helped the government come after us. They had helped the government build a case against us in New York. Turns out that quite a bit of the information that they had provided to the government was false. I had to give up numerous claims to go back against the government for violating our rights. But what I was unwilling to give up was to be able to take action against those confidential informants. And they were doing it for their own gain. They were trying to extort a business out of an individual by weaponizing the government. So if somebody wants to do the work, they can go find out who the defendants are. Those two defendants were confidential informants for the government, and we have every intention to take an action against them.
Some people have construed this settlement agreement as Rare Breed looking out for Rare Breed, where you guys had Cargill, you've got Chevron deference no longer being an issue. You guys had all the momentum. You could have pushed it through. You could have gotten something more binding, not just a district court decision out of Texas, but something out of the Fifth Circuit, maybe even something out of the Supreme Court, if you would have pressed ahead with this. But instead, you entered into an unenforceable agreement with the government, or the next administration could just tear up to save your own asses. How do you respond to that?
First, I'd like to start by saying, until you've walked a mile in my shoes, go fuck yourself. Like, I'm not interested to hear what you have to say. It's really tough for people to see the bigger picture, especially all these guys that have been kind of reviewing the settlement agreement on, the socials or on YouTube. They're not looking at this from 30,000 feet. They're looking at it through a microscope. So you have to take into account that we've got the case in the 10th Circuit. Now, we could have dumped that case, but it looked like it could have gone the other way. But there was no chance we could dump the case in the 2nd Circuit. And there was a high likelihood that it was going to go the opposite direction. Now, I feel highly confident that we would have prevailed in the 5th Circuit, but also a reasonable chance that they would have pared back the injunctive relief that Judge Okconor issued. In Judge Okconor's order, only organizational plaintiffs were protected. Only organizational plaintiffs were supposed to get their triggers back. Now, under the settlement agreement, everybody gets their triggers back, not just organizational plaintiffs, not just named plaintiffs, everybody gets it back. So that is a big deal to consider. Would we have won? Like, overall, would we have won? I don't know. Like, I'll be real honest, I'm not sure that we would have. Things would have gone our way in the 5th, probably not in the 2nd, but where does that leave everybody? I'm not sure where that leaves everybody. But with a settlement agreement, we have that certainty. Now, did we have to give up a little bit? Yeah, we did have to give up a little bit. Did I mind giving up a few of the things? Not so much. But I feel like the settlement agreement was kind of what secured the deal for everyone.
Possible future defendants. Hopefully at this point there won't be any. But they didn't have anything to waive in court other than a couple decisions here or there, or just really the legal argument of it. Now they do. I like to look at it as, I think the 2A community would have been very pleased if Judge Okconor's ruling in July granting summary judgment and final judgment had been the end. The community would have said, great, and there's no appeal. That's still in place. And not only is that in place, but there are other protections that people outside the judgment now have because of the settlement agreement.
Personal question.
Yes, sir.
How much did you spend on litigating this?
Many, many, many millions.
Okay, millions. We're talking millions of dollars litigating this.
Yes.
Was it worth it?
Yeah, but I will tell you what, in hindsight, I'm not sure I would do it again. I was very naive when I started this. I really, truly thought in my heart of hearts, we would argue the merits and whoever was right on the law would win. And boy, was I wrong. I mean, couldn't have been any more wrong. I didn't realize that the government would lie, cheat, steal. I mean, I literally had federal agents get on the stand and tell outright black and white lies, and they're never held to account. So knowing what I would be up against, I'm not sure that I would do it again, because I can tell you what, in hindsight, looking back, so many things went our way that led us here. And if any one of those things went the other way, we would have been toast.
And you would have been out millions of dollars.
Millions of dollars, and possibly doing, big prison time.
Yeah.
So, I mean, it worked out, but I don't know that it would work out, again.
Lawrence, are you still not drinking? Because I got to tell you, at the end of all this, I would pour myself a big fat-ass glass of bourbon.
No, I still don't drink. It's been like 6.5 years now, no drinking. I'll tell you what, though, there has been a discussion that since this is all over, that we would all get together and have a drink, so that's still on the menu, but yeah.
Gentlemen, I appreciate you coming on the program, talking to us about this. There were a lot of questions out there about it. If I want to get a force reset trigger from Rare Breed, I can only get it from Rare Breed, at least for now, right? No distributor or dealer?
That is correct. We're not selling to distributors or other retailers right now.
This is a little awkward because we're on YouTube and it's like, well, how do I get one? Well, I can't ask you that because YouTube prevents us from getting URLs or directing people on how to buy components. But it's even trickier now because you've mentioned that there have been several websites that have popped up that are imposters. You go to buy from them, you ain't getting shit. You're paying for it and you're getting nothing.
They're taking your money and not sending you anything.
But we can't, I'm sorry, YouTube, but we cannot tell you what Lawrence's, his URL is, nor can we identify the imposters because otherwise YouTube's going to take this video down. But if you want to support Lawrence, you've got a lot of models coming out.
That's right. So we currently have 2 models for the AR that are in production, and we've got a model for the AK-47 that's in production, and we've got one for the MP5 in production. We have a handful of others that are still in late stages of development, but they're not far behind.
Josiah, my rights are being trampled. I'm looking for representation. How do I get in touch with you? Where do you practice?
Yeah, so I'm with Dillon Law Group. Our former boss, Harmeet Dillon, she's now Assistant Director of Civil Rights, Attorney General, Assistant Attorney General. We think of each other, of ourselves as freedom fighters at Dillon Law Group, and easy to find us online.
You can actually use your URL because unless you're selling guns at Dillon Law Group, because that would be awesome. But how do I find your website?
It's just Dillon Law Group, DillonLaw.com.
Thanks again for being on the program. Viewers, if you have questions for these gentlemen, you want to leave them in the comments, go ahead and do that. But in the meantime, thanks for watching. Make sure you like, subscribe. Take care.